Yes.
Yes.
Worships with great respect to the Sanapur Millard.
Yes.
Scheduled tribe employees have filed the writ petition to consider their objection in fixing the seniority Millard. In similar circumstances, on 8/8/2023, the Sanapur Court was pleased to direct the respondent to consider their objections. Cover the order, Millard. Kindly have it to me.
Kindly permission to lordships, the listing lordships, matter pertains to the relative services, vital cases, your lordships.
Which matter?
No lordship, to the 17 case, your lordships. The hundred something directed back to this,
Why do you want your file at early hearing?
one of the petitioners, your lordships, across of age 57 years, lordship, waiting for justice, your lordships.
Why he wants? Why do you want an early listing?
No,
He filed an application.
says it.
If you want early listing, file an application. We will order on that, list on that, right?
Yes,
Please
sir.
file.
Okay, yes.
Yes, madam.
I'm Dr. Sweta and I'm appearing as party in person for writ petition for 2023 in the Honorable Court. However, there was a small disturbance on 5th of October. It was passed the same court by the previous Honorable CJ, and there was a small disturbance, and because of that, it was reduced. But I apologize for the to the Honorable PV, for the Honorable Justice, and he was happy to take up the matter in the same bench. So it would be great if it can be posted to the same bench, because our case is.
No, no. What is your case and why you are mentioning? You have to make a mention to Registrar Judicial on administrative. It will be brought to my notice. We will deal with it. This we can't do, madam. I can't pass an order on your prayer right away. It's a different combination. Yes. You approach Registrar Judicial. Yes.
Presentation.
It will be done. Yes.
Item number 1.
I will pass an appropriate order. It will be done means your whatever representation you have made, appropriate orders will be passed on that. Yes.
Item number 1, my lord.
Oh, she did not call. So, yes. Called? Okay. Okay.
My lord, to save the time of the Honorable Court, my lord, case number 13, first item, my lord, we don't have any objection for allowing the contempt appeal.
Huh?
Well, I am appearing for the appellate. My friend says that he has no objection for appeal being allowed.
Oh.
The first one.
See how fair he is.
Yes, because I appreciate it.
You appreciate, no? And but we in turn will expect the same fairness from you in some other case.
Yes.
And you have to be fair because you represent
We
the
have been, Millet, because Millet, the order of the learned single judge has been complied with. Complied with. But despite that, the Honorable Court said that
it has been complied with belatedly.
Millet, after filing the contempt, that was only the reason. All the four are
This
similar.
appeal.
All the 4 cases are similar, arising out of the same.
1, 2, 3 and 4.
Yes.
My lord, in case of 2, 3 and 4,
He doesn't have.
I request for time to submit my reply after it.
Reply?
My lord, 3 weeks.
All right. So 1 and 13, you don't have.
Yes, my lord.
1 and 13. Item 1.
Because
2, 3 and 4 my lord.
All are similar, arising out of the
Similar.
same order.
But there is lot of contempt among the appellate my lords. I would like to file a reply affidavit my lord.
What, you don't have a role, right? We will pass an order like this.
My lord, if I don't have a role, I should not be called here my lord.
You said I don't have a role.
No, not
You said no.
no my lord. That appellant in item number 1 my lord, he doesn't have any role in the contempt my lord. That is why we said.
Oh,
In case of 2, 3 and 4, there is lot
you
of.
want to file a reply.
Yes.
Let him file.
But in the meanwhile, your lordship may stay the order, Milord. Otherwise,
Nothing happens.
if I don't pay the Milord fine, Milord, I need to undergo the imprisonment. That is only the reason. Milord, let him file found.
You pay the fine. What is it? It will be subject to result of the outcome.
Your lordship may.
Not on the question of
Yes.
admission. Notice.
A senior advocate is appearing online, Your Lordship.
Huh?
Ranjit Kumar is appearing
Who?
on item 5, my lords.
Huh?
Ranjit Kumar, senior counsel, is appearing online.
Huh?
Item 5 and 6.
Huh?
The item 5, 6 and 7 goes together.
Huh?
Item 5, 6 and 7 goes together, Malan. I am appearing in item 7. Item 5 and 6, Malan.
Yes. Huh?
Your Lordship can hear me, my lord.
Yes, yes.
Please, my lord. So this is a case, my lord, where according to us, my lord, we had complied with the order because the direction was to consider that order. If your Lordship will find, is that page number
Debatable.
41.
Preemptive. They are held guilty.
Page 41, my lord, was the
All right. Yes.
page 41 was the direction, my lord, which was issued to us,
Ah.
of which
When-
contempt is alleged against me.
When did you consider their cases?
My lord, I considered them twice, my lord, on 23/9/2019
Ah.
and then again on 30th March 2021.
All right.
After having considered the case, my lord, we rejected that they were not eligible and they could not be appointed in terms of the order. And my lord, in fact, the division bench, my lord, in the appeal at page 97 records that once an order has been passed, the order of the single judge stands complied with. If your lordship just see page 98, page 97, running page 97, my lord.
Yes.
My lords have at the foot of the page, there is a bold portion.
Ah.
For the division bench order. May I place it, my lord?
Ah, yes.
The writ appeal is also not maintainable for the simple reason that the petitioner appellant suppressed the factum of already implementing the orders of the learned single judge by way of issuance of proceeding dated 23/9/19, rejecting the claim of the respondent and petitioners, and as such, it cannot be said that the petitioner appellants are aggrieved by the orders of the learned single judge.
Yes.
And in fact, the content, my lord, at page 135.
All right. All right. It's for admission bill. Yes. Mark the presence. What is 5, 6?
5, 6 and 7, my lord, goes together against the
7.
same order.
All right. Same
I'm
order.
grateful to your lord.
Very obliged.
Deeply obliged.
Hmm.
Dated 16/8/2023, my lord. So far as allowing a complaint which was filed by the appellant herein, who is the fifth respondent in the writ petition, to the collector by giving details of and particulars of our land title and to direct the respondent, unofficial respondent, to not to interfere in the lands in which she is cultivating. Now, your lordship may kindly see, my lord, page 54. 54, that is against that order. A mere representation was given to the collector.
How criminal dispute has been converted into a civil dispute? What is, the finding that we,
For a moment, your lordship, with great respect, I am the petitioner.
Ah.
The fifth respondent husband approached the civil court and failed to get the injunction order. Thereafter, he is invoked his own methods. Whenever the officers are changed or
No, so what?
then she filed an application before the district collector seeking police protection. Already a case was registered, which was pending before the SHO. While matter is pending, she filed an application seeking to grant police protection. That application is entertained by the district collector and directed the Tahsildar and RTO to submit a report before passing a.
What is the law? There is a Supreme Court decision when police protection should be provided or should not be provided.
Not the collector exercising the powers as a magistrate, not at, it's a civil court, not in the agency areas. Not the orders
No,
passed.
but when the parties have approached the civil court and they could very well seek an order of injunction, what is this?
The suit itself, in the suit itself, page 63, the orders have passed in suit, IA 94 of 2020 in OS 96 of 2017.
Yes, Mr. What do you say?
Now,
You had filed a suit already.
Suit is pending, my lord.
What is the suit?
Suit is for injunction against the writ petitioner. No, I am not on that, my lord. Now, my lordship,
we are asking what happened to the suit?
suit is pending, my lord. Suit is pending.
Application for temporary injunction?
Dismissed.
Dismissed. I is dismissed.
When?
Your lordship,
8/11/2017.
17.
Way back 17.
Right. So then what is police protection?
No, it's not
Did
a-
you file an appeal against that order?
She did not carry the matter.
What?
8/11/2017, your application for temporary injunction was rejected. Did you file an appeal?
No appeal is filed, my lord.
No.
Now, one submission, lord. The complaint your lordship making, page 56. My main contention is, my lord,
Police protection. The cause of action is only entertaining an application, not the police protection.
now there is no cause of action for filing the writ petition.
59.
Only on the application filed by the.
1 minute.
Yeah, much.
We will hear you, don't worry. Yes. So, you filed a suit for injunction, did not get an injunction, did not challenge that order.
Yes.
So, order of dismissal of injunction has attained finality.
I am not on that.
Then what
Now
happened?
we are saying that by creating a fabricated document. Another passbooks were got issued by the writ petitioner. Your Lordship, against that matter, you approach the revenue divisional officer. Your Lordship may kindly see the orders of the revenue divisional officer. Your Lordship may find at page 67. It is a statutory appeal under 5B of the ROR Act.
Correct.
In that regard, the learned appellate authority is said that the documents which were obtained by the writ petitioner are fake. Yes, that is the
No, that is not the subject matter of this writ petition.
The-
Subject matter is order granting police protection.
no, we have not sought any police protection. That's what I want to see. Your Lordship may kindly see the complaint that I filed. Your Lordship may page.
No, but it has not been.
The collector-
1 minute. Police protection has not been granted to you.
No police protection. No, I am not on that point at all. Your Lordship cleverly saying that it is a criminal complaint.
Huh?
But my learned friend is saying that it is a criminal complaint. I have approached the honorable collector only to see, and the collector has also powers under
Where is
section
the impugned order which was impugned in the petition? Let's see.
Page 54, Miller, this is the complaint filed by the fifth
54.
respondent.
No. The order which was
Yes, sir, that is the orders.
I have dismissed on page 63.
Not a, Your Lordship
not
say-
order which you challenged in the
67.
petition.
Page 67.
No. What I am challenging before this honorable court, the fifth respondent application is entertained by the district collector
Hey,
for
where is
grant
that
of
order?
police protection.
Where is that order?
No order.
That is page 54.
No order.
Against my representation to the collector, no orders are passed. He called for only reports from the RDO and Tahsildar. Against that matter, he approached this honorable court, stating that it is a criminal complaint and the collector cannot entertain.
Page 54 is the Telugu version. 55 and 56 is the operative portion, Miller. It is declared Uppala Krishnamurthy along with the following things to kill them for cultivating the land, due to which we are very much provide
No.
police protection.
Huh?
You will have kindly see page 56, first paragraph. What more required? She is asking police protection from the collector. The collector wanted.
So what happened?
Nothing.
Yeah.
At that stage, I have abandoned the.
No.
Orders have been passed.
No orders is passed.
Then-
Now the act is repealed. Now there is no act. The act is 9 of 2020 is introduced.
Sir, is the issue is confined to criminal or civil? First,
That's
you
all.
be clear on that.
But she filed a complaint before the police. Police
No,
registered
so-
the crime.
That what is the order passed on the basis of the complaint or
What is
representation?
necessity to file an application before the district collector seeking police protection indirectly? She is a lady, that's why the district collector had to take-
No. So whether the district collector has provided police protection?
No, he
Then-
called for the report from the Tahsildar.
That he will pass appropriate orders. When he passes you, then you have a cause of action.
Yes, but he has no power under the repealed act.
You cannot prevent anybody from this thing.
But the Lordship may pass
Yes,
the name.
yeah, we will modify the order by saying that as the right now there is no order by the district
Yes.
collector, and as and when this district collector shall pass an order after hearing both of you in accordance with law,
Yes,
and in case such an order is passed, you will be at liberty to challenge it, right?
yes.
Yes.
You can point out everything that he had filed and injunction
Yes,
refused
everything is
What-
there. While
Party presence
while
with-
passing the interim orders by the Leonard Single Judge, it is clearly recorded the.
No, but there is no order that you will appreciate, right? There is no order by the district.
Yeah, then today the district collector not passed any order.
No order. This intra-court appeal has been filed against an order date
Education.
May I please? That before going to the grounds of dismissal by the single judge, I wish to give some brief facts of the case. That the applicant has submitted an application seeking certain information under Right to Information Act relating to the applicants for establishment of a private university, and also the applicants who are successful in securing private university under Telangana Private Universities Act 2018. The applicant asked for two types of information. The first information is the applications, detailed project report, and compliance of the regulations of the relevant statutory bodies. Second information, the recommendations of the expert committee and verification report of the expert committee for granting private university status. Both the documents are public documents as defined under section 74(1) of Indian Evidence Act 1872. You will also for a moment may see the 74 of the Indian Evidence Act. That I have given a slip Millard. Public documents, documents forming into act or record of the acts of the sovereign authority of official bodies and tribunals and public officers, legislative, judiciary, executive, or any other any part of India or the Commonwealth of foreign country, public record kept in any state or private documents. The adaptation of definition of public documents under section 74 of Indian Evidence Act has been accepted, approved by the Honorable Supreme Court in Ferrani Hotels Private Limited, which is State of Information Commission, Millard. This is the copy of the Supreme Court judgment, Millard.
Give Madam Right to Information Act. You should immediately take out. He is referring to Right to Information Act. Not that when we say, when you ascertain all the relevant books are kept here, show me once the roster, which subjects we are dealing. Yes.
But it is
which judgment?
Para 15 of the judgment, Millard.
He is giving judgment, no? That
operative portion, para 15, Millard. The purport of the said act is apparent from section 6 of the said act, which provides for manner for making a request for obtaining information. In terms of subsection 2 of the section 6 of the said act, there is no mandate on the applicant to give any reason for requesting the information. Any body should be able to obtain the information as long as it is part of the public record of a public authority. Even private documents submitted to public authorities may under certain situations form part of public record. In this behalf, we may be useful to refer section 74 of the Indian Evidence Act defining public document as under. Millard, my secondly, Millard, out of 12 applicants submitted application, 5 were granted private university status by making amendment under section 10 of the Private Universities Act 2018. After declaration, notification of a private university, the said institutions will become public authorities, and there cannot be any objection for submitting the information belonging to those universities which are notified by the Act of the Assembly as a private universities. They become public authorities.
why your writ petition has been dismissed?
Basically, 3 grounds. First ground,
Suppression.
suppression. There is no suppression. The applicant admittedly is the chairman and correspondent of a society submitted an application for establishment of a private university. But same is not relevant for the purpose of the writ petition. Yes, the petitioner herein submitted the application in his individual capacity. Well, section 6.2 made it very clear that purpose and the object of information is not relevant. Section 6.2 of the RTI Act 2005. I have not suppressed any information, Milord. Milord, the first ground, Milord, my contention that education is not a business and exemption under section 1, exemption under section 8.1D will not apply, not be accepted. Yes, the applicant is the chairman and correspondent of a society which is also submitted an application for establishment of a private university. Milord, for that, Milord, my first reply, Milord, it is a well-settled law that establishment and administration of educational institutions recognized as an activity and means of livelihood under section under Article 19 of the Constitution of India. Milord, the imparting education can never be trade or business, a service to the society. Milord, your lordship aware of the TMA Pi ratified by Islamia and PA.
This all irrelevant, TMA Pi and
Yes,
this thing.
Yes,
All irrelevant. Your application seeking information under RTI Act has been rejected. The order has been upheld by appellate authority and learned single.
Yes.
You should meet the reasoning. So that's why we asked you. What it has to do with TMA Pi Foundation?
Milord,
What your case has to do with TMA Pi Foundation?
Milord, it was rejected on the ground that
We are listening to you patiently. That doesn't mean that you will say anything.
I'm sorry. I'm
So
sorry.
otherwise, we will have to request some senior counsel to assist us in case you are unable to comprehend the
I'm sorry. I'm sorry.
Confine yourself to, you rightly pointed out there are 3 grounds. Confine, give an answer to those grounds. That's it. Nothing turns upon TMA Pipe Foundation.
Second, Milord, the orders of the respondent 2 to 4 are rubber stamped pro forma order without any reasons and not result of valid decision making process. Third, Milord, none of the orders of respondent 3
Where is that order?
order of rejection, Milord.
Ah,
The last statement kind of page 52, Milord. Page 54.
54.
Fifty-four is the rejection by the second respondent, Milord. It is rejected with reference to the RTA application cited. I am to inform you that your application does not come under the provisions of the section 2F and 8J of RTA Act 2005. Hence, the same is hereby rejected. Mere quoting provision without giving reasons cannot be justified as law. Milord, the first appellant also has rejected, Milord, on the ground that, Milord, you will have to make kindly see page 60.
Page
60, 60. I am to inform your application does not come under the provisions of section 2F. Yeah, the information sought for not specific and also it relates to third information which attracts section 8D and section 11 of RTI Act 2005 and the same is to be hereby rejected. 8D is connected with the trade secrets, commercial confidence and intellectual property and 11 is related to third party information. And I have not sought for any third party information, Milord, which is kept with the PIO to keep it confidential. I have only sought for public documents, Milord. Milord, the third ground, Milord, none of the others gave any reasons as to the applicability of the exemption under section 8.1D. Milord, it's settled law that rejection of the order should give reasons and they cannot quote mere provisions. Milord, the fourth objection, Milord, to apply section 8.1D, two conditions should be complied with conjunctively. One, my lord, the information sought by the appellant should fall under any of the categories of, that is above, whether commercial confidence, trade secrets, and intellectual property. Second, my lord, the disclosure of the same should harm the competitive status of the third parties. My lord, in the instant case, there is no determination whether the information falls under any one of the categories specified under section 8(1)(d). Mere casual and mechanical invocation of section 8(1)(d) cannot be substantiated under law. My lord, even assuming existence of a copyright in favor of a third party, it does not bar the PIO to submit the information, my lord. Yes.
Reasons of page 53. Yes.
Yes, submission of copies of the documents will not amount to infringement of copyright, my lord. 6, my lord, onus to prove that the information sought by the petitioner falls under the exempted category is on the PIO rejecting the application. Disclosure of information is the rule and non-disclosure is an exemption. 7th, my lord, in the similar circumstances, my lord, the division bench of Jharkhand High Court, while dealing with the disclosure of the tender allotment documents, made abundantly clear, my lord, once the decision of granting tender is taken, there is no justification to keep it secret, as people have got right to know the basis on which the tender has been granted. The facts, though, are different. The broad principle is the same, my lord. In the instant case also, with respect to 5 societies, the decision of granting private university has been taken, and there is no secret in disclosing the information relating to those 5 universities. My lord, 8th, my lord, the right to information is a fundamental right, a facet of right to freedom of speech and expression. Unless until the respondents demonstrate that the information falls under exempted, under reasonable exemptions, it cannot be rejected. You lastly may kindly see the second ground, my lord. Non-disclosure of the information that the petitioner is also the chairman and correspondents of the applicant submitted the university is an act of suppression, my lord. I have not suppressed any relevant information for the purpose of the writ petition, my lord. Second, my lord, as I have already explained, my lord, the appellant is a chairman and correspondent of the applicant for the private university. The same is not relevant. Yeah, the application for right to information is submitted by me in my personal capacity, my lord. Third, my lord, the applicable test in the right to information have to be exemption test, but not the purpose test. My lord, section 6(2) of the RTI Act made it abundantly clear that applicant need not give any reasons or purpose seeking information except the correspondent address. My lord, the very case of Supreme Court on which reliance is placed in the order of writ petition, my lord, I may read 2 lines, my lord, last will come to my lord. Clearly, motive or purpose for making request for information is irrelevant. Being extraneous cannot be a ground for refusal of information. Further, the said decision states that, however, this is not to state that motive or purpose may not be a relevant factor while applying the public interest test. In the instant case, I am not pleading any public interest, my lord. Third ground, my lord, since the information sought by the appellant related to third parties, it cannot be given without following the procedure prescribed under section 11 of the RTI Act. But it is for the respondents to decide whether the procedure under section 11 has to be followed or not. It is not connected to me. But at least partial information I am entitled. There are 2 categories. One category applied and their application has not been decided. Second category of 5 applicants, they are decided, declared as the notified as the private universities. To that extent of the private universities notified, I am entitled for information.
apply.
Third, on the question of admission notice.
Mr. Sricharan, my lord, in this matter, my lord, we appeared for the writ petitioner in the writ petition, my lord. Lordship, my name may be deleted. It was inadvertently.
Your name is not there.
Sricharan Therapur, my lord, for the second respondent, my lord, it's named, my lord. We appeared for the appellant, my lord, in the writ petition. Our name was printed.
No, he is appearing. He has
Yes,
not
my lord,
engaged you, obviously.
He is appearing, my lord, in part in person. Our name is printed, my lord, that may be removed.
Where it is printed?
It was printed as our
Office is directed to delete the name of Mr. So and so as counsel for response.
No, please, Your Lordship. Lordship, this writ appeal is against the order, dismissal order passed by the learned single judge. There is a delay of 39 days, Your Lordship. IA number 1. There is a delay of 39 days.
No. Please tell us how writ petition is maintainable, under which law this thing, elections are held of whatever committee. What happens? And at least we are unable to get head and tail of this.
So it is against it.
How a writ petition is maintainable? When does a writ petition lie?
Lordship, it is.
When a writ petition can be filed?
Your Lordship, it is against the eligibility.
No. When can? Please tell us. You must have learnt as a student of law.
Against the state.
When a writ petition can be filed?
Against the state, Your Lordship, if any fundamental
For
right.
violation of a fundamental right or a statutory right. Which statutory right is infracted? Under which law elections have been held? Whether, if any, it has been held under any law. Whether that law provides for any remedy. Nothing, like just.
Petition was filed, Your Lordship, and
You better withdraw this, Mr. with the liberty to take recourse to the remedy available to you in law. Otherwise, we will have to dismiss it, obviously. You also know that under.
But I'm bringing the, after the dismissal, I prefer the writ appeal. Anyways, I'll withdraw it, Your Lordship.
It's not maintainable, right?
Should at least remand it back, Your Lordship, because
How?
I'll withdraw it.
We are asking you that the writ petition is, how is it maintainable? You are saying it should be remanded. How this can be done?
I'll withdraw it.
Thoroughly misconceived, right? This intra-court appeal heard.
Right, please. Not a victory.
But in this school, my lord, of GO is under challenge. But wherein, my lord,
We have passed an order, similar order.
Lord,
Admitted for hearing this thing. Shall be this the order?
Lord, may I make one submission?
Ah.
But I'm told that, my lord, your lordship, I also pass another order in writ petition, wherein, my lord,
We had asked him last time how many recruitments every candidate who is ineligible in terms of the rule in all the states should be, why you should take the trouble of filing petition every now and then. So all candidates who are ineligible under statutory rules, they should be allowed to submit their application, right?
if that order, my lord, is there, my lord, should suffice.
You are taking that seriously. Huh? What is the prayer?
My lord, inadvertently, my lord, I sought two prayers, my lord, suspend the GO and, my lord.
There is no question of suspending GO.
No, your lordship, I'll
That
file-
we will reject your prayer.
My lord, application, my lord, I will file, my lord, so that, my lord, I can, your lordship may permit me to write the exams.
This
my
is
lord.
the order. Meanwhile, recruitment shall be subject to outcome. This is the order which we have passed. You file an application, do whatever, we will
Yes.
consider it.
Yes,
If similar relief has been granted to others, it will be granted to you also.
yes.
Right.
No, your Honor, one submission, last date for receiving of application has been over, your lordship, by 28th of this month.
That means you don't know what is the order which has been passed.
Lordship, earlier your lordship was allowed to receive
Tell him.
applications, your lordship. But now, last date for submission.
We are not sitting here to explain. Right? The order has been passed. File SLP against it if you are aggrieved. You don't know what is the order passed. Not sitting here to explain it to you what is the order. He did not understand. You will have to repeat for him. Go and explain it to him.
Because
He has not understood, right?
in those cases, will only be approved before the last date of submission of application, your lordship.
Go and tell him, save us. Go there and tell him what is the order which we have passed. Go first explain it to him. It's not our job to tell him.
I am aware of your lordship. Lordship, but
What is the order which has been passed?
direct to receive.
Tell him. No order has. Listen to him. He is
There
telling
was
you.
direction to subject to result of repetition, lord.
So, we have passed an order, Mr. It is subject to this thing. Either you will have to file an application seeking vacation of stay. You tell him, Mr. He hasn't understood. You have not done your job clearly. You listen to him. What order has
I am
been passed?
aware of it, your lordship. I am aware of it, your lordship.
Not aware. That's why you are looking at us. You are not aware. Tell him what order has been passed. All right. Next case.
Lord, may I make one? Lord, I may take it next week, not so that I'll file it.
What? You find an applications, get it listed. It's not like this.
Lord, item 12, my lord, this is matter pertaining to secondary grade teacher, my lord. IA2, my lord, seeking direction for permission to receive applications and participate in the recruitment process. That your
The
lordship,
order.
sir, please to.
Secondary grade teacher.
Yes, my lord. This is the same.
Madam, this is the order. List for analogous hearing, then at the end of it, along with WP number 28766/23. Is over.
Yes, Lord. Lord,
Then last date is over.
Lord, if your lordships recollect, my lord,
No.
on the 20th
Leave
of,
it.
on Friday, my lord, I made a mention, a lunch motion, my lord, on Friday.
Ah.
Your lordship said that the date of exams is not announced.
Ah.
We'll consider it after
All right,
vacation.
yes.
Since the date of exams is not announced, your lordships, my lord, we're pleased to, Lord, suggest that we may consider it after vacation. I'm deeply opposed. At item 12 also, my lord, 13 also, my lord, is there is IA2, my lord, seeking direction for participation in
Same order.
No, my lord, this is school assistant, my lord. Your lordships
Item
also
12 is what?
secondary grade teachers.
Item 12 is secondary grade, madam. 11 is secondary grade, 12 is secondary grade, 13 is.
School assistant.
But no orders henceforth.
Yes.
These are the by way of an additory measure and say it is further directed all the three that the interim order passed in these cases shall not be treated as precedent, as the last date of submitting application for the post in question has already expired. Right.
Wait, please, Your Lordship. While this is an order against, writ petition against my lord, the order of DRT, my lord, we are suggesting my lord to pay the entire amount within a period of 6 weeks. My lord, the stay of auction was sought and which was dismissed. My lord, two other loans, my lord, on which stay of auction was granted and order was passed because we have a counter claim. As my lord, those two loans were in respect of my lord, where I.
But you have to give them a proposal, right?
But we'll, in fact, the notice itself says 3 crores 14 lakhs is due under this loan. But we will pay that amount within 6 weeks' time. I'm saying, my lord, the writ itself can be disposed of within that period. Other two loans, my lord, there is already a stay order of DRT for which, my lord, a particular condition was imposed. And my lord, we have paid. And there is a counter claim in respect of those two loans.
Before I go into the merits of the case,
No, nobody is going.
this case, we have already conducted the auction. He paid the total amount and sales certificate was issued and we have delivered physical possession to the property to the auction purchaser. And
See, this is the role of a bank, right? They have become a real estate agent. How this thing? So when auction when it was in?
conducted 4th October,
Huh.
on 4th October, and he paid the total amount. And subsequently, they filed further applications before the DRT, and those matters were
What can be done?
on 26th October, and those IAs were also
The sales certificate was issued when?
on 26th. I filed the document.
You tell the date, right? You know it or you don't know.
No, in fact, they have suppressed the fact that we have already filed this copy of the document before the DRT. Before the DRT, on 26th.
No, we are not getting. See, Mister, in our minds, the still
On 18 and
Page 15.
you file an appeal.
Page
with
15.
what?
Page 15, my lord.
No.
See, in the result, IA so-and-so is dismissed. However, auction, if any, conducted in respect of the scheduled property pursuant to the sale notice shall be subject to the result of essay. Question of them issuing, my lord, a sale notice does not arise even in respect of the impugned order because it is subject to the essay that is pending. But my lord, this order was passed on 3rd October. 26th October is the impugned order passed, my lord. I do not understand as to how they say sale notice is already issued when I am saying I'll pay 100% loan. But even if it is issued, the essay will be allowed in my favor. My lord, the reason once I pay the 100% loan.
They are interested in your property, not money, right?
That is the problem.
That
is the difficulty.
We told you in the beginning. Very often we notice the behavior of banks as real estate agents. Therefore, nobody should take loan from them. With their conduct, they point out that if you take loan from us, we will not spare you. You and your property. So that they are not interested in their money. They are interested in their property. But what can be done?
Now, what can be done, my lord, is that any.
What can be done is
in this case. I'm
we
only.
are not, what can be done in the sense that still the 3-judge bench decision of Supreme Court stares at us. You have an alternative remedy of an appeal.
Well, there was a.
We only heard you because you said that you are not contesting, you are willing to deposit. But bank is not prepared to accept, no.
But the entire loan, once it is repaid, even if the sale is made, but that would have to be set aside because it is made subject to essay. Lordship must see page 15. Page 15.
No, the sale has been conducted on 410, right?
And 2610 is the impugned order, not allowing further proceedings.
Sale certificate issued when?
No, my lord.
On 18th October, my lord, I have filed before the tribunal. They have received a copy on that day.
So you place on record the documents with regard.
I will file.
Let him place on record the documents.
Yes.
When will you file?
After 1 week.
Next week, Monday. Learned counsel for respondent bank prays for short accommodation to enable him to
May I please your lordship. But, senior counsel Eldovich and is leading me in this matter, my lord. Due to his personal inconvenience is not available. However, my lord, the batch of writ petitions, my lord, in this matter, it may be taken up along with that batch, my lord.
But this matter is unconnected with the batch, if I may say so with respect. On the last occasion, there was a writ petition which was pending, which they withdrew. And that was with respect to refusal by the Debt Recovery Appellate Tribunal to condone the delay. Now the impugned order which has been passed by the Debt Recovery Appellate Tribunal is in view of the fact that...
So in any case, he is seeking an adjournment. So which date?
Fairness, should have told us. We have been waiting for the last half an hour.
My lord, for coming for the first time, my lord.
First time, no. Actually, you should have told senior counsel that I am seeking adjournment. He would not have waited here, no?
My content is coming for the first time in the morning. Other side counsel approached me. I informed him that I will be seeking time as senior is not there.
All right. So when do you want?
Next week, anytime, my lord.
There's no great hurry. Let him come 2 weeks later. Because 2017 sales certificate is given.
2017 to me, my lord. I have for action.
2017.
We paid about 53 crores.
All right. What, 8th November? Learned, write his name, learned counsel for the appellant, praise for
So I request to take up this matter tomorrow, my lord.
tomorrow. Tomorrow. Learned counsel for respondent.
This honorable court was pleased to
appear for the
direct them
respondent's
to
home.
file an additional affidavit stating what happened to the representation given by the appellants. They have caused
Mr. Ramohan Reddy, my lord, standing counsel. My lords, we have filed the additional affidavit, my lord.
Tell us the date. That's all.
Yes, my lords.
Shops have been allotted to them, right?
Yes, my lords. Shops have been allotted to them, my lords, as per the affidavit which was filed. My lords, it was allotted to them on.
Then if it is not, then the learned single judge has proceeded on a wrong assumption of fact, right? So then file review, please. You file review. If he has not decided.
I'll file a new writ petition because they have stated that they have passed an order on the representation given by.
No, we are concerned. Yes, madam, what is the date? Except that you will say everything else, right?
Date, my lords, what they have said, my lords, the present municipal commissioner is the in charge, my lords, who has taken the in charge, my lords, very recently, my lords, on 9/10. On 9/10. So, my lords, he has.
She doesn't know. Give it to. Please read this order and then tell. Please read it aloud. Yes. Order. What does it say?
Therefore, the municipal commissioner in charge to Tupran municipality is directed to file an additional affidavit disclosing the date of decision on the representation dated 6/1/2023, failing which appropriate order shall be passed against him.
You have to just simply, that you have not done in 2 minutes. You have to just tell us the date.
Yes, Malas. The date of the consideration, Malas, we have filed, Malas, it's 16/10/2023, Malas. 16/10, Malas. They have considered because, Malas, already the shops have been allotted to the earlier persons, Malas.
Date of decision is?
They have filed, Malas, 16/10.
Where is it?
Along with the additional material papers we have filed.
Additional affidavit?
Yes, Malas. Additional
Which
affidavit.
page, paragraph?
Page number 6, Malas.
6.
Well, it has been recently considered. Like this.
So you will have to challenge this order, Mr.
That's what I'm trying to.
Okay. So we grant you the liberty to challenge this order.
Yes, my lord, but a status quo of
This-
10 days time may be granted.
Nothing. What?
Because they have not yet served the copy of the order on the party. They only submitted.
Given the additional.
Got the copy.
I can't challenge on this photocopy. I have to get the certificate or some copy.
We don't know what is. You challenge it. Yes.
10 days status quo may be direct. Enable me to file the fresh petition.
What status quo? What are they doing?
Already, Josh may kindly see the earliest order in this written.
No. Why status quo? What
They
they
are
are doing?
They are doing under the interim orders. They are doing the business of small vendors, bringing in cars, small.
What is the respondents doing? They are demolishing your shop.
They are trying to demolish.
Where is that?
Sorry to interrupt.
the
It was already demolished, my lords, at the time of filing the writ petition itself.
Not demolish. They are doing.
You have not served them. Let the status to be maintained for 10 days.
Now, my lord, what happened is these people who are there, the street vendors, they have been allotted in the.
No, madam, it has taken 3 orders of this court to ascertain this order. You did not, you have not served a copy on the petitioners, nothing. He has now
Obliged.
Whatever it has demolished, well and good.
Obliged.
This intra-court with consent of the. So have you complied?
May I please, your lordship?
I'm for the respond.
Have you complied?
I am for the appellant, my lord, your lordships, in fact, my lord orally directed us to file our operations and as regards to the amount of royalties and the dead rents paid,
There
my
is no
lord.
question of oral. There is an order, madam. If you don't know, then say don't know.
On 12, my lord, on 12.
There is no oral direction.
That's prepared, but I could not submit, my lord, I grant me a
Don't say then. This is not an oral direction. It is a part of the order.
and I apologize for it, my lord, but it is.
Learned counsel of the appellant
My lordship, in this matter, I am for the appellant on paper. I am representing. Kindly may be taken up next week, my lordship.
Why?
Not feeling well, appellant. May be taken up next week, my lordship. Kindly take into consideration. He's not feeling well.
Learned counsel for the appellant placed for adjournment on the ground that the
But I'm appearing for respondents 4 to 6 here. I request 3 weeks time for filing counter fraud. I received remarks.
Earlier 3 occasions, but they have taken time, my lord. My only minute.
Finally, I received remarks.
But my instructions are that, my lord, now they are again, my lord, giving promotion to the, my lord, respond number 9.
let them file counter. What?
My lord, that is done, my lord. Respond number 9 is again given promotion, my lord. I will, my lord, because I am the senior to, my lord, respond number 9. Even then, my lord, they are.
It has to be heard, right? What can be done? 23 use no. Have you seen item number 32 in the list? Please see. Interesting. 32, item 32.
Yes.
Of which year?
True.
Huh? 89 and 97, Mr.
True.
Read petition.
But my lord, only request is, my lord, let them implement the GO in a close spirit, but only that, that with that prayer.
There is a claim for promotion. You will get it, Mr. If you succeed in the petition. What is there? How can we allow your petition, direct them to give promotion? How will you defend our order, supposing if it is allowed? He has not filed counter. He will say court did not even grant us time to file counter.
My endeavor is only.
The court would say, the Supreme Court would say that High Court should focus on deciding 89 writ petition instead of deciding 2,000.
My endeavor is, my lord, let them implement the GO, my lord, issued by them. But that's only, my lord.
Then nothing. You learned counsel for respondent 4 to 6. Praise for India's grant.
My lord.
Yes.
It's a covered case, my lord. The last time.
No, did you file the amendment?
My lord, I paid.
Huh?
You played
When?
on 28th, my lord.
28? Where is? 28th October.
My lord.
No, 28, then incomplete petition. Do you have a copy? All right, heard on IA.
My lord.
What happened, Mr. Explanation? This case is over, but we are.
Bloody. Informed Tahsildar to file this affidavit, my lord, explaining how she.
So what happened? He has filed.
She has not responded yet, my lord.
All right, so bailable warrant.
Even
Learned additional government advocate. responding to like
Even on 610 itself, my lord, we informed last.
despite information being sent on, huh?
My particular can be of responding for 1 and 2.
It's the appear for petition.
Yes.
That's this writ petition, my lord, challenging, my lord, the action of respondent number 1 and 2 in classifying the loan account as fraud, my lord. My lord, I have challenged this on the basis of the judgment of the Honorable Supreme Court. Thereafter, my lord, the respondent has issued a circular stating that they will reverse all the fraud classification and they will abide with the Supreme Court judgment. My lord, the circular is at page number 94, my lord's mechanism.
No, Mr. After classification of the account as NPA, right? Action under 13 and 14 was taken.
Not about NPA, my lord, it's about classifying the loan account as fraud.
No.
NPA classification is on
one. We are trying to understand. So your loan account was classified as fraud when?
But they don't give a date, my lord, of that. They don't give, my lord, they only submit in the pleadings that.
Thereafter, action under 13 and 14
Yes,
has
my
been
lord.
taken.
Yes, my lord.
You have filed an appeal and approached debt recovery tribunal.
Yes, my lord.
What has happened? It is pending.
It is pending, my lord. We have
Why can't you take this plea there?
But this plea, my lord, last time, my lord, same query, my lord, the interim order passed by the tribunal, my lord, I have placed along with a memo. My lord, the debt security tribunal, my lord, has not gone into this issue while passing an interim order, number 1. Number 2, my lord,
But
this.
you can urge and we can direct that since, I mean, there's no point in duplicating the proceeding, right? One point, this point NPA fraud, then supposing NPA in another petition.
Classification of the account as NPA is not based on fraud. It is what they contend before the tribunal and the tribunal is also observing. My lord, I am contesting that. Insofar as classification of the account as fraud and NPA, both are different aspects, my lord. The fraud classification.
Therefore.
But I need not challenge it because they have admitted that they will reverse it. My lords, may kindly see page 94 circular of the bank itself. They have admitted that in view of the Supreme Court judgment, we are reversing all the classifications. Page 94, it's a circular issued by the bank itself. My lord, the relevant portion is on page 102. It starts at 94.
No.
Kindly see, my lord, for a moment, my lord, 102. I will read only 2 lines, my lord. 102, my lord, point number 5 of this circular issued by SBI.
What is this circular? 1 minute. What is this circular?
Lord, this is a circular issued by SBI in terms of, my lord, judgment passed by the Honorable Supreme Court in the case of Rajesh Kumar Agarwal.
Circular issued by CBI dated?
Circular dated 26 May 23.
26 May?
23.
20. So, what clause 5?
Page number 102, my lords, may kindly see, my lord. Clause 5 of the circular. The fraud cases declared prior to Supreme Court judgment on 27/3/23 and the borrower approaches a court of law. Frauds in the loan account declared prior to 27/3/23 and already reported to RBI will be reverse classified wherever the borrower contests the classification in court of law. Upon receipt of authentic intimation along with copy of petition filed in the court of law from a borrower who has already been declared as fraudster prior to 27/3/23, AGM FMC will submit a proposal to FIC for reversing the decision of fraud declaration. FIC will reverse the fraud decision and issue instruction to AGM FMC to issue SCN to the borrower. This is the procedure they are adopting in terms of the Supreme Court judgment, which stated that all the fraud classifications without giving a show cause notice are illegal and they have to be reversed. They are following this. What I am asking is a hearing on the fraud aspect. That is my prayer only. They have to do it as per the Supreme Court judgment. And there is a judgment of this learned single judge, page 113 in a similar case. In view of the judgment of Honorable Supreme Court, they have to do this exercise again by notifying me, calling me for an explanation. and giving a show cause notice to me and following guidelines given by the Supreme Court. Kindly see, my lord, the guidelines of Supreme Court, my lord, I have enclosed the judgment. Para number 65, page 88, my lord. Running page 88.
88 and
The judgment of Honorable Supreme Court starts at, my lord, page number 69. But I am reading page number 88, para 65. Body altum partum therefore entails that an entity against whom evidence is collected must be provided an opportunity to explain the evidence against it, be informed of the proposed action, and be allowed to represent why the proposed action should not be taken. Hence, mere participation of the borrower during course of the preparation of forensic audit report would not fulfill the requirement of natural justice. The decision to classify an account as fraud involves page 88, my lord. Running page 88, my lord, para 65 of the judgment. May I read, my lord? The body altum partum therefore entails that an entity against whom evidence is collected must be provided an opportunity to explain the evidence against it, be informed the proposed action, and be allowed to represent why the proposed action should not be taken. Hence, mere participation of the borrower during course of the preparation of forensic audit report would not fulfill the requirements of natural justice. The decision to classify an account as fraud involves due application of mind to the facts and law by the lender bank. The lender bank, either individually or through JLF, have to decide whether the borrower has breached the terms and conditions of a loan agreement. And based upon such determination, the lender bank can seek appropriate remedies. Therefore, principles of natural justice demand that the borrower must be served a notice, given an opportunity to explain the finding in the forensic report, and to represent before the account is classified as fraud under the master directions of the fraud. Then, my lords, may kindly see page para number 79 also. But that is the finding on page 92, minutes, para 79. Page 92, minutes. In the light of the legal position noted above, we hold that the rules of body altum partum ought to be read in clauses 8.9.4 and 8.9.5 of the master direction of fraud. Consistent with the principles of natural justice, the lender bank should provide an opportunity to the borrower by furnishing a copy of the audit report and allow the borrower a reasonable opportunity to submit a representation before classifying the account as fraud. A reasoned order has to be issued on objection addressed by the borrower. On perusal of the facts, it is indubitable that the lender bank did not provide an opportunity of hearing to the borrower before classifying their account as fraud. Therefore, the impugned decision to classify the borrower account as fraud is vitiated by failure to observe the rule of audit. In the present batch of appeals, this court passed an interim order restraining the lender bank from taking any precipitate action against the borrower from time being. In pursuance of our aforesaid reasoning, we hold that the decision of lender bank to classify the borrower account as fraud is violative of the principles of natural justice. The bank would be at liberty to take fresh steps in accordance with this decision. In accordance with the decision of the Honorable Supreme Court, they have issued the circular which I have pointed out. The bank has to undergo an exercise once again, by issuing a show-cause notice to me and also after hearing me.
Where is the order declaring your account as fraud? What?
There is no order at all, my lord. That is on their internal basis only, my lord, they say that it is declared as fraud.
Where?
My lord, first time they say in a counter affidavit filed before the DRT, my lord, they say it first time, my lord, I have enclosed the counter affidavit copy at page number 6.
So in case they treat, they will follow the procedure prescribed. That's what is good enough. In case they treat your account as fraudulent account, they will follow the procedure prescribed in the circular dated 26/5.
Correct. Yes, my lord, they have to follow.
That's what we will say. That will satisfy. There's no other
The classification is before the judgment of the Honorable Supreme Court, my lord. I am treated as fraud account before the judgment of Honorable Supreme Court.
So whether their this thing account you have treated as this thing fraudulent.
Not in the counter, whatever my grandson is telling. In the IA 1927 of 2023, in securitization application 226/2022 filed by me, Lord, I stated in my counter that they were declared as a fraud. It was one of my main ground, Lord. challenge the said IA, my lord.
When have you declared fraud?
Lord, that instruction I have to seek, my lord. Today in the
Huh?
morning only I have received for Vakalat.
He says there is no order.
Lord, that I have to seek instruction from the bank, my lord. Only certain facts I like to elicit before this honorable court, which
Hey.
was not permitted by petitioner, my lord. My lord, in IA 1927, my lord, he was not granted any interim relief, my lord. In that IA, my lord, I filed my counter grounds, my lord, that he was declared as a fraud. Challenging the non-grant of any relief, my lord, he filed one under writ petition before this honorable court. That is writ petition Y WP number 18635 36 for 2023. There, my lord, this honorable court is directed to the Honorable DRT to reconsider the said IA as a fresh. Now, my lord, once again arguments have completed. It is pending for orders, my lord. He is challenging my grounds of declaring me as a fraud in this writ petition, my lord.
And what is the IA pending?
My lord, IA
What is-
1927
Mr.
is for interim relief, my lord.
You have the copy of the writ petition?
My lord, I have the order copy, my lord.
No, copy of the writ petition filed by him.
No writ petition. My friend is referring to securitization application, my lord, not writ petition.
No.
There is no writ petition.
Your writ petition, so that we can make him understand what is the relief claimed in the petition. Do you have the copy of petition filed by him? No.
No, I have the order, my lord. Writ petition.
I have served. It is
He
there.
says he doesn't have.
Petition. Presentation.
Petition I have.
Huh?
Yes, my lord. This writ petition I have copies, my lord.
That's what we are asking. Come to page 24. What is the prayer? Read it for our benefit because we have not read it.
It is therefore prayed that this honorable court may be pleased to issue an appropriate writ, order or direction, one in the nature of writ of mandamus or such other appropriate writ, declaring the action of the respondent number 1 and 2 in classifying the account of the petitioner account as fraud account and consequently classifying the account loan account as NPA as on 15/7/2020 as illegal, arbitrary and violative of Article 14, 19 and 21 of the Constitution.
So when have you declared his account as fraud account?
As so far as this concerned, I have to take instructions from the bank, my lord. But this main ground I have taken as a defense in count as counter in IA 192 from the 2022, my lord. That was challenged by him before this honorable court.
That we have understood. You are repeating it. But there has to be an order, right?
I have to seek instruction from the bank, my lord. Today only morning I have to take so far.
Learned counsel for the
The
petition submits.
Date of NPA itself is
Let him
2020.
seek instructions. Learned counsel.
another writ petition, my lord, WP 18365.
Yes, one petition you have filed.
No, my lord, sir, I have not filed any writ petition. The securitization application is pending.
Securitization application, my lord, there is an IA.
That is
They have not
challenging
granted any
the measures under 13(4), my lord. Nothing related to fraud.
My lord, my main ground is that you declared as a fraud, my lord. The loan account is declared as a fraud account. That was referred to this honorable court challenging it, my lord. It was sent back.
Very difficult, mister. What to do? I mean, we are not sitting here to convince you and to make you understand. If you don't understand, what can be done? The jurisdiction of this court under Article 226 cannot be taken away by anybody. You don't understand seemingly the controversy. What can we do? We can't keep on repeatedly telling you. What can be done? List next week. Hmm.
The petitioner secured a suit of she could not join within the time. She could not report within the time, Lordships.
So what can be done, mister?
Now, Lordships, there are 2 seats available in third respondent college, Lordships. If
there is a likelihood of extension of time for the further period. In such case, the university proposing to conduct counseling for CQ category, competent authority quota, not management quota. But any seat is left over, these colleges will on the basis of merit, that is left to him. But no orders can be passed in this case. Because having issued a allotment letter, he was directed to join on 7/10/2023. He could not join. The leftover seat was filled in the subsequent phase of counseling, mop-up phase of counseling.
When?
No, mop-up phase of counseling, will I file counter?
We haven't got. When?
The date is, will not be. Lordship, 14/10/2023.
What can be done?
Sir, it might be one clarification. After 14/10, Lordship, there are further notification is issued on 25/10. Even as per 25/10, Lordship, there are 2 seats available.
In the
third respondent, this is a list of not joining list.
Even if it is available, it is under rules, he is not eligible. Even if the seats are available, a candidate was allotted a seat, failed to join, but he could have applied for extension, my lord. Before conduct of the subsequent phase of counseling. Seats are vacant.
Where is your counter, mister? We don't have the. When have you filed? Yesterday.
Yesterday they sold on, yesterday they might have filed. Lordships, we have immediately filed a writ petition, Lordships, but you.
Yeah, but why you did not join, mister?
Lordship,
What happens? See what happens to a candidate in accordance with rules. See who doesn't join.
Lordship, she loses a seat, Lordship, but now their seats are available. Lordship, seats cannot go wasted, Lordship, even according to the university also. That is the reason, Lordship.
It is for them to consider whether.
Yesterday, Lordship, in a matter.
You consider his case in accordance with the merit, right?
Consider whether if counseling is conducted for management quota. That petitioner applied under management quota.
All right.
Even for management quota also, Lordships, as per GOMS number 107.
No, so in case the counseling is held for filling up of the management quota seats, your candidature will be considered.
Lordships, one more submission, Lordship. Even if the seats are unfilled and the management, they are not conducting management quota counseling, Lordship, they will send a merit list to the colleges to fill up. At least they can include my name in the merit list. That can be done.
Last may kindly see, under the rules, a candidate who was given an allotment, failed to join, is not eligible for further rules of.
Where is it? Which provision? Which rule, Mr. Rao?
27, I just pass on. Well, counter and fine.
127. We don't have your counter. To tell him, Mr. Rao, Counter is not filed, it has been returned. Why it is returned?
I just check. Lord, kindly see the rule. Your lordship dismissed the number of writ petitions citing this rule. Top, your top.
Where you don't have the order, Mr. Rao. We have passed.
Lordship.
You don't have the order. We have passed similar orders.
Yes, lordship.
You don't have a copy.
I will check it out.
What my submission is? No.
What can be done?
Lordship, this GO is.
You tell us why you did not this thing report of before
Lordship,
7 6.
she was suffered with a fever, or she was bedridden.
What?
Lordship, furthermore, Lordship, one submission, Lordships. In this GO, Lordship, one submission, this GO is issued.
But how do you meet this rule?
That reason, Lordship. This GO is issued for seed blocks, prevent seed blocking. Lordship, in first paragraph order, the company considered to prevent seed blocking. Here I intend to take a seat. This GO and the purpose of GO is to prevent seed blocking. Here I am intended to take a seat, Lordships. I have lost an opportunity, but Lordship, a genuine Lordship, I am not preventing. Enter seats are now enter seats go vacant. They can give to a candidate who can study. It is not that they can, because of the work, they can keep the seats vacant. Yesterday, Lordship, what has happened? Supreme Court has directed 2182 seats are all over India are were unfilled. So it was extended till November 15th of competent quota to fill up the seats. Seats can't go vacant, Lordship. This GO is purport of GO is for seat blocking. No, enter roll.
Seats can't go vacant, therefore zero. Right. Yes, sir.
PG. PG. Now here, Lordship.
No eligibility criteria can be
Here,
prescribed.
Lordships, I want to take a seat, Lordships. Purport.
No, he was allotted a seat. He didn't report.
He was allotted a seat, Lordship.
He didn't report. This is now he's depart from further round of counseling. What can be done?
2 seats are available, Lordship, so I can have.
No, but last date of admission is over, Mr.
Yesterday, Lordship, they didn't file counter. For their counter, Lordship, it was adjourned to till today evening, Lordship, they have to send the entire list to the NMC. But NMC, Lordship, as per yesterday Supreme Court order, Lordship, that has not, even as per their submission, it is being extended till November 15th.
Even otherwise, blood petition is not entered. Even otherwise, it is for him to approach managements. If any leftover seats are there, they will give admission.
That liberty we grant you.
That liberty may be granted. If any leftover seats in the concerned college, Lordship, I may permit.
Otherwise, it will form a precedent, violation of rule.
Cannot take. Yes, mark the presence. With consent of the parties, the matter is out finally. Paragraph.
28.
Yes, Mr. Rao, 28 same. Copy today.
Well, Lordship, kindly say, my lord, shall not form president. But next
Peculiar
time-
facts we have said. No, we have not said anything. We have granted liberty. There is no direction by the court.
I pay for the petition.
I filed the wakalat today itself. I have not received any material papers.
Lordship, I will serve the material papers to my friend, my. Have.
Just now only I have filed.
Learned counsel for the petitioner and
Requested for passover, your lordship. Learned friend requested me to request the passover, your lordship.
Lord, some matters are passed over, blood, waiting before this honorable Lordship, put it tomorrow, day after as the Lordship pleases.
He requested passover, your lordship. I'm requesting on behalf of. Yes.
is asking for tomorrow.
Yes.
Tomorrow. Learned counsel for petitioner prays for adjournment.
Both matters.
Both matters. 26, 27.
And Biplab lordship. So regarding illegal construction of the.
Report has been submitted in the sealed cover to the court.
Submitted?
Yes.
Where is?
Sealed cover in the court.
Ah.
It's on. October. 28th October. It is.
We have.
Interpretation.
Yes.
Right. Say, illegal construction in the FTL lands, your lordships, without getting.
No. We are writing an order. We have perused the report. Yes.
May I submit our judgment, your lordships, fairly covered by the honorable apex court also, your lordships. In FTL lands, any temples also be removed. That is there.
We are admitting just now we have received the report. You don't know what is the report. You know it.
I don't know.
That
Please say.
you are arguing Supreme Court. What is, we are admitting it. There is already a stay in your favor.
But yesterday also there are constructions are going on. That I want to say.
That you have to. This report says that there is no construction. Petition is admitted for hearing in compliance of the order dated
Early explained hearing your lordship, because
Petition
aged
is
about
admitted.
75 years, your lordship, early hearing.
See item number 32 in the list. 32. 32. Not your case, Mr. But see of which year it is pending.
Yes.
32.
But here,
Give the list to him.
two reasons is there, your lordship. Why? Because
Give the list to him. See.
No need, I understood your lordship.
No, please see. For your benefit, see, please.
But here,
32 of which year?
yes, sir, 89.
That
But here life threat also is there. That is my humble request to your lordship. So life threat also is there. Now he is continuing with the gunman only. Right?
So you apply for if there is any threat, whatever. We will give you protection.
He is having your lordship now.
And then what else can we do? We cannot sit by the side of the tank and watch. What do you expect?
Early disposal. I am seeking only early disposal. You are basing on the.
So it has no impact on you, right? Item number 32. That's why we asked her to show you the.
Understood. People apply.
I appear for the petition in item 30. I request to pass over, your lordship. Council is on legs in another court, your lordship.
Not pass over today.
Correct. We also endorse where you are stand. Tomorrow or day after. What day after?
Friday, because these two matters were regularly.
Learned counsel for the petition, mark presence. Friday. Yes. Huh? This Friday, you should let the special bench. Okay. The bench, it has to go to next Friday then.
Yes.
Next Friday.
Tomorrow, your lordship may have it.
Tomorrow, if unless intervene for it.
Lordship may kindly see, because they had expressed some urgency. It was actually suggested yesterday. Then at their request, it was posted.
Short pass over.
I have arranged all my other work. That is my genuine difficulty.
Short pass over, your
I have
lordship.
been here since morning because of this matter.
Day after then. Day after, mister?
Leave it.
Day after.
Okay.
Not on Friday, day after. Yes. Yes, you are appearing in 89.
Yes.
32. What? What is it?
The matter of 1989 was disposed of in the year 2001. 2001, the Saturday petition was disposed of. Thereafter, the LR of the deceased writ petitioner filed this review application, which is special leave, and also with cardon delay petition and impleading response number 325. Finally, I am asking to review the said judgment. I am seeking a review of the
What ground?
delivered by the Honorable Court in the year 2011.
What is the ground? To seek review.
The point involved in the reviewing, main error apparent of the face of the recording as per the regulation 2 of 70. This is the agency area, Miller. There is a provision of, there is a law
1 minute,
to grant.
1 minute.
Yes.
Who are you? Who are you?
No, I am the
LR
sons of the
Sons of
original claimant. the petitioner's father is the original claimant before the settlement office. Settlement quota was granted in his favor. Later, the Tahsildar carried the matter to appeal. Appeal was allowed. As a result, the writ is filed before the Honorable Court. The Honorable Court disposed of the petition in the year 2011 on dismissing that on the ground he failed to prove the position over the land. The very same crucial aspect covered under the document is already placed before the Honorable Court in the writ of certiorari papers are there, my lord. So without verifying that, your lordship kindly see the, after passing of the Honorable High Court orders, the proceedings are there, my lord. That is, proceedings dated 10/11/1952. This is the estate is taken over by the government. The said document clearly indicates that the petitioner's father was in possession of the property much prior to abolition of the estate, abolition act. So the crucial document is not considered. That's the only point.
Which crucial document?
You must kindly see the Telugu portion 10/11/1952. After the writ petition judgment, the next page.
Now, what is 10/11/52?
52 is the estate taken over by the government, the all lands vested with the government. In those proceedings,
Page 21.
yes, Telugu portion.
Just 1 minute.
The petitioner father position is recorded in the year 1952. The provision of
Yeah, what is 52 document? That's what we are asking.
this is the settlement officer before passing of the order. A Pachanama was conducted. Who is in possession of the property was recorded.
Panchanama prepared by
The
settlement officer.
at the directions of the settlement office.
All right.
Only in schedule area, the only provision available for grant of Raitwari Patta in favor of the non-tribes, that is the only regulation 2 of 70. Under regulation 2 of 70, section 7, the person who is in position continuously 8 years prior to commencement of this regulation 2 of 70. So this is the document based on that Patta was granted. Later it was set aside. At present, your lordship kindly see the order passed by the Honorable Court. Without considering this crucial document, this is the writ of certiorari, the entire record placed before the Honorable Court. The commissioner, this is the last page of the judgment. The land revenue receipt 1374 firstly, there is no proof of position and required under law. The director of settlement was presently wrong when he mentioned that the appellate claim for survey number 20/45 is genuine when the position prior to 1945 till 1/7/1971 was not proved before him. The director of settlement erred in appreciating the facts and law 2 of 70. No proof of such position was produced before this court by Rambabu. Since the authorities below have come to a conclusion that the position was not land at the relevant time, and even the admitted case of the petitioner, we have found that he has not been in continuous position of 8 years. This is wrong in view of the next document. This document is already placed before the original settlement of from
This
settlement.
was 52.
Yes. This was not considered. This is clearly indicates that the petitioner's father is in possession of the property. Unless I got possession continuous 8 years, I am not entitled for grant of
This
title.
document is of 52.
Yes.
He's saying it's 52 position has been given.
The petitioner father, it is recorded in the.
Is it on record? This document not there.
This document is very much available on record. So this is the writ of certiorari.
No, in the here in the petition, did you file?
Yes.
You have filed. So your submission is since 52 you are placed in position, therefore you continue.
Yes, the middle of the paragraph from 1965, 69, 70, Choichunanu. So the petitioner father is in continuous position and doing cultivation. That is the statement recorded by the settlement inspector before granting the patta. Let's continue to middle of the paragraph. This is not my statement. This is the actual ground net position, who is in position as on that date.
But in the order, it has been recorded as 7 years. That's why we are asking.
Yes.
In the order, it is written, it is stated that the position is only for 7 years. In the order, in the writ appeal order,
yes.
the order, it's been stated that the position, you were in position only for 7 years. That is the finding. Please see internal page 3 of the order.
Yes, 1 second.
Last para.
The petitioner terms 7-1 year regulation under 7-1. A person is entitled Raitwari Patta even if he was not a member of the scheduled tribe. It shows that he was in position not less than 8 years immediately before commencement.
Read further. Last 3 lines.
8 years before the commencement of the regulation. Even the director who has decided the case in favor of the petitioner had not given finding of the fact that the petitioner was in position prior to 8 years of the commencement of the regulation. He merely had stated that the land revenue receipt for the year 1964 had been produced. The regulation admittedly coming to operation in 1970. Even if it is accepted that the receipt of the land revenue would show the position of the petitioner even then between 1964 and 70. So the period would not be 8 years. 8 years, but as of today also we are position in the land.
You have filed the document. Where is the document in the material?
This is after the judgment.
I don't ask him, he will seek it then. The review stop is limited. It's, what is this? He said 1952 document on which so 10, 11, 52 it says 25 years means 1925, 27. 1852. But you see 8 years prior to coming in. There is no document to show. Maybe in 27. That's it. It says 25 years. That's it. Anything else?
Yes.
Third. What is it?
The council is no more.
Huh? Yes.
Council is no more.
Huh?
Council is no more. I trust.
Then we will decide it later. What has happened? This petition has been decided? Pending. When disposed of? Allowed by division bench. Where is the order sheet in this process? Yes. This, he will be entitled to refund of the amount. Yes. The yes, it is shown to be pending. So you, madam, within bracket, you write IA1 of 2002. And this IA, this is how
The requisition become infectious, my lord.
Learned counsel, infructuous,
Yes, my lord.
review petition.
Petition IA 2 of 2015.
Ah, right, same thing. Give her list, madam. Write his name. What is his name? His name.
Yeah, here before or restoration. Kindly allow the restoration fee, so that the main matter we are.
Nothing next week. Today is the most auspicious day. What do you think, right? The client. No senior counsel. You are senior counsel for this case. She will issue you a notification for this WP of 1997. You are designated as senior counsel. He has given C. Nothing, madam. It's not like 97. How many? No. How many years now?
I just submit one.
No. How many years it is pending?
I do accept a lot, but in 2011 the petition was allowed. Then the respondent had gone to Supreme Court, my lord. That was in Supreme Court in 2015. It was remanded back. At that point of time, the petitioners have not informed the council, my lord, that it was listed. They also did not know the matter was listed. That's the reason why we couldn't appear on that day. That's the only difficulty.
No, it will be allowed only subject to condition that you will argue it today. Otherwise, we are not inclined. Madam, 26 years, madam. There is a limit to it. I mean, we all should feel genuinely ashamed. I feel ashamed that I am heading a court where the writ petition of the year 1989 and 97 are pending, and you have guts to seek an adjournment. This is not, madam, it's not like an officer of the court. You describe yourself as an officer of the court, right? No, I feel ashamed. There's no question. Sorry is a very light this thing. We are sorry to tell you that it will not be adjourned. Come what may. It will not be adjourned. You again go to Supreme Court. That High Court, after allowing the restoration, should have granted us adjournment for 3 weeks to prepare the case. We will not. No. Nothing. You are a senior counsel.
The matter is in high stakes, my lord. It's one.
Then nothing, no high stakes. You can again go to Supreme Court, right? High stakes, again go. There's nothing. Once it has gone. We don't want to, madam, we don't want to enter into a discussion. We told you that after 26 years, it will not be adjourned. At least my conscience does not permit me to be a party to adjournment. I will not. We will not do it. No, sorry. Nothing.
Senior counsel is on account.
Don't do it. Nobody is forcing you to appear.
Instructions.
Don't, we are not forcing you to appear. Don't appear. Don't appear. There is nothing. If you don't have instructions, please do not appear. Nothing. You call him. We are going through because the burden is on us to write a judgment, right? You are not telling us anything. So we are reading the file. You can call your senior. Tell him that it will not be adjourned. We don't intend to repeat. Yes, yes. Now we have to deal with on merits. Which was the earlier order? There has to be an order of remand by Supreme Court. Where is it? Where is the order of remand and the earlier order passed in? You keep it with you, madam. Who will write an order? You. Then if you keep, you will have the responsibility to write an order then. Where is the order, earlier order, and where is the order passed by Supreme Court remanding? Where is? 12-4. No, read petition. This is the order of remand. April 2013. But where is the order earlier deciding the rate petition? Where is the order, madam? By which petition was decided?
Where are the demand notices? Page.
There was first demand notice is in page number 8. 108 is the first demand notice, no? 109, 8 and 9. In fact, the principal amount is paid, madam. Only in regards to the interest, we were given suspension of the order. And now in 2015, they have issued another notice, madam, that we have the suspension petition that is also paid. And they have not specified what's the amount due as on that date. Even for the restoration, they don't have any objection. They have not filed any counter, madam. The second demand notice is along the suspension petition, my lord, at page 8.
Drugs Control Order Number 1970. 1970. Drugs Control Order.
Have you replied to these notices?
Pardon?
Have you replied to these notices?
Yes.
Where are the page?
Before the notice, we have done an explanation of how we are not charged with these amounts, my lord. Apart from not considering that the notice were issued. Then the petition was filed as Supreme Court.
Yes. MRB presence heard on IA number. Heard on IA number 1 of 2014. Madam, 1970. How is it, madam? Huh? She's saying not there. What did you do for 1 hour? At least you should have taken out. We were dictating, right? Yes. So what have you written? Ah, ah. Paragraph. Opening paragraph you write again. What have you written? Opening paragraph. Ah, the delete. The petitioners have assailed. Delete. Write the whole thing afresh. Delete everything. In this writ petition, comma, the petitioners have assailed the validity of the impugned demand Now this take care of 2000 thing. Yes.
Make introduction. This is an application for restoration load of the writ petition of 2000.
It is allowed subject to condition that you argue.
But we are ready, my lord. We are ready to argue. It is challenging a 41A notice. But I must also mention that
41A notice
under the Indian Stamp Act. My lord, I must also mention that there is another connected writ petition of 2016 which was directed to be posted along with this. It is not listed. But while it is not listed, I can still argue this.
You are the counsel, right? So result would automatically be the same.
Yes, my lord. In the sense, my lord, it is connected in the sense that there was a dismissal of this writ petition. A fresh writ was filed because of a subsequent order that was issued. But that writ petition was tagged along with the present one. That is not listed today. The subject matter would be similar, except for 3 times penalty has also been sought in that writ petition. Here, there is no penalty that is mentioned. The restoration application is an application in WPMP number 14655 of 2016. That is
That's allowed. That's allowed. Go ahead.
Yes. The substitution petition may also be allowed formally, because this is a.
What is substitution?
The company has now been amalgamated.
File.
That is IA number 1 of 2023.
That is a petition. Where is petition? Order sheet. So, Mr. Yes.
Petitioner company, the petition.
You are ready, no?
Hello?
You are ready.
But I am ready, in the main matter.
Okay. We'll take it up tomorrow.
Yes.
We'll allow these applications. It continues in the list.
Yes.
Tomorrow at same number.
Yes.
Immediately after motion hearing cases, it will be called.
Yes, I'm ready.
Right? You have seen the level of assistance being offered to us in the previous case. It's all our responsibility, right?
Counter has also been filed.
Counter is also
right. Heard on IA1 of 2016. And app. Be taken up, even though in physical form, but it will be taken up tomorrow because this is of 2000.
Yes. Yes. Deeply obliged.
You tell Mr. Reddy that this should appear whether or not it has been digitized or not. It should appear. Huh? No, noted means you don't tell Mr. Reddy now that it should be repeated this case. You prepare a synopsis, Mr. to help
Yes,
us
sir.
like why we have to.
Yes, sir. We'll prepare a short synopsis with a list of things.
Yeah.
Deeply obliged.
This
query
is completed on 4 months.
Query,
the report will be, the report is already forwarded to the state government. Or should I defer it by 2 days more and find the report?
let it continue in the list then.
Yes, my friend wants 2 days time for filing a report. I have no objection, but what I was suggesting was, he gives a report, Lordship may have it after 10 days, so that I'll go through it if required, we have to take notes. That would be convenient.
Mr. Harinder
Next line of the report.
mark the presence, Mr. Prabhakar, learned senior counsel, Mr. Harinder Prasad. It's all subject to decision in this appeal.
Subject to my lord's consideration.
14th November, Mr. Prasad.
Yes, a friend does have a copy of it.
I will.
Obliged.
Deeply obliged.
I'm still waiting for the. Obliged.
Deeply obliged.
In respect of others also, my friend may have to give instructions, because the inquiry was directed against 5 officers. Today we are only concentrating on the IAS officer, but the other 5 officers also my friend will give instructions.
Was respect to the IAS officer and place the report.
No, not that, but the other officers.
Other officers.
They will also.
They are witnesses in this case. All the officers charged therein are witnesses in this case.
Yes.
In favor of this.
You tell us what have you done about others?
Yes, ma'am.
My lord, I'm representing the officer. I have filed counters to all the IAs. Pleadings are complete in this matter.
14th, it's coming up.
No, there is a respondent's application to fix a date, my lord, of these 2 applications.
Fix a date?
My lord, the 2 appeals filed by the government, but we have the respondent writ petitioners. We are successful. They filed a writ appeal. This matter was in fact was heard at the earlier bench and reserved for judgment. That, my lord, was released on the elevation, my lords.
When?
Early date, lords can kindly fix up, my lords.
Any date after 14th November. 15th November. Heard on IA.
IA 1
of 2023 taking into account.
Okay. Obliged.
What, Mr.?
Application for a consistent review.
Ah.
Where your lordships
the property of the petitioners, which is nothing to do with the loan transaction. Neither is a guarantor nor a borrower. And a different property of me, which is a running functional, was taken possession by the collector.
What
And
is
you kindly consider.
No, but what is wrong with this?
No,
Against order?
No, my submission is, your lordship, under 300A of the constitution, your lordship, this is nothing to do with, earlier, this honorable court has directed to go to the debt recovery tribunal. And debt recovery tribunal has said that it's barred by law, without even exclusion of the time that has been lapsed in the writ petition proceedings. Now, I only request your lordship may kindly have 2 minutes. Now, I request your lordship may kindly have a glance at page number 51, your lordship.
Nothing wrong. You are seeking review of this order?
Review, your lordship may kindly, 57, your lordship may kindly consider. This is
Order dated 14 September.
your lordship. And I am sorry, your lordship, on that day, I have logged on, I was in Chennai, I logged on to this virtual hearing. In the beginning, it was proper, it was good. While I was starting my arguments, it got disconnected. And your lordship has observed that no representation, that is and I have also filed the proof.
Yes.
I only request your lordship may kindly, page number 57 is the memorandum of title deeds. I request your lordship, page number 61, the property that was mortgaged, the registered mortgage, your lordship, 61, is admeasuring 2662 square yards. It's a vacant site. And unfortunately, page 26, your lordship, the district collector has taken possession of, your lordships have seen it, that the scheduled property, which I brought to your lordships kind notice at page number 61, is a vacant land, open land in survey number 159 by B2. And your lordships may kindly consider at page number 26, a running function hall was taken possession belonging to the petitioner, which is nothing to do with the loan transaction or the title deeds. Page 26, your lordships may kindly consider. That is in survey number 155. And extent is 1 acre 8 guntas of the petitioners. Running a function hall is 1 acre 8 guntas. The property that was mortgaged is 2662 square yards in survey number 159 by 2. All these documents were filed along with the writ petition, your lordships, but unfortunately I was not there and I could not assist your lordships properly. May I request your lordships, the same is evident from the certificate given by the Tahsildar stating that page 76, your lordships, page 76. A certificate issued by the Tahsildar himself. This is to certify that MBR function hall is running. In survey number 155, Shilpa Venture Road, Potireddipalli village, Sangareddy Mandal, Sangareddy district. The applicant given the application, namely Manne Sri Ramalu, is the first petitioner, son of so and so, Potireddipalli village. Application dated 12/10/2022. After verification, the survey number is issued this certificate. Now, I brought to your lordship's kind notice, the property that was mortgaged is in survey number 159 by 2, a vacant land of 2662 square yards. But the functional belongings to third parties, the petitioner before your lordships, was taken possession of. And your lordships may kindly consider, an application was made to the collector stating that it is improper and irregular, and a notice was issued by the collector, which is at page number 70, your lords.
So we'll see, you supply a copy of this review to.
Your Lordship,
Huh?
I file your Lordship. I only because running functional is.
No, you supply a copy to the council for bank, we will see.
I have already filed your Lordship. I have furnished to them also. The collector's action. I only
Yes,
pray
just
your
to find out.
Not printed. I'll find. Their name is not printed. Bank's council name is not printed.
Who is the council for bank? You find out, you have delivered possession, right? You have
Yes.
understood.
Yeah. The unfortunate situation, this is
The orders
the
of
only
the DR.
season, your Lordship, during October,
So that's why,
November.
so let them appear, no? We will give a short date, you
Much
supply.
all right. I leave to your Lordship.
So what is this thing, the mortgage property is?
Mortgage property is 2662 square yards, your Lordship. Which your Lordship may kindly
No,
consider.
of which survey number?
159/2,
And possession has been taken off?
155 to an extent of 1 acre 8 guntas along with the structures running functional.
Mister.
But even the order passed by the collector.
Learned counsel for the petitioner has made. $93. What is it? Decided, pending. No. Since decision district mining charter. No, so this must be decided. It must have been decided. They will not tell. Huh? Rahul. This is decided that she won't know. If we ask him, then they will tell. It doesn't know anything. Says on royalty and MRT. This is a review, right? No? Review or written? Array, madam, see what happened to 2001 volume 7 SCC 358. You people don't have SCC online. Wherever, so you find out 2001 volume 7 SCC 358. What happened to 2001 volume 7 SCC 358? It was referred for this. It has been decided, right? Different name. It is District Mining Officer versus Tata Iron and Steel Company. Yeah, I have read it. This has been referred, decided. Says on royalty. Royalty. You just find out SCC online, mister. What, like they don't know anything. They not, madam, to what has you find out here. What is she doing? Get 2001 volume 7 SCC 358. You don't know anything, right? Ah. We knew. I told my brother, don't ask any question because she would not know anything. The burden is on us. Very good. I think this has been affirmed. Array, mister. This you find out from this cess and other taxes on minerals within bracket Validation Act 1992. Its validity has been dealt with. For type these words, unable to get it. You are also sailing in the same boat. They don't know anything. You also don't know. How, madam, my staff in Bangalore had SCC online. My court officer used to give me. Sir, this is what has been. You people don't have any idea. Huh? Yeah. 2000 page. Two thousand one. Validity has been upheld. Where is it? Last page, at least give operative portion. Yes, madam, right. You are not even curious to know what is it. Nothing, right? None for the petitioner. Yes. No, don't write none. in this petition,
Last occasion, the Mr. Fadla Shetty is appearing online, my lords.
what is it?
Yes, minutes, may bring to your lordship's notice, with the lordship's permission, we have prepared a note.
Huh?
We have prepared a note, my lord, with regard to the reports which have been given.
Huh?
But it's,
You will decide. Huh? You write the order then, if you are not prepared to hand over.
bullets. May I request.
Order sheet.
The.
Yes, they have to file a
After,
state.
after looking into all the reports which have been filed by R1 to R4, I prepared a note saying that some of the things which earlier pointed out to this honorable court saying that they need to say about these things. They have not complied with. I have given a note, detailed note up to page 2, up to page 2 it is formal regarding the deeds of the orders and all that. From page 3 onwards, each of the item I have discussed mandatory rainwater harvesting. But summary with regard to the present report also I have stated, saying that one of the statement in this report of R3 at page 6 is, it says all existing buildings in municipal corporation and urban development authorities shall construct rainwater harvesting structure within a period of 6 months. But that is nothing but as vague as possible. What are the steps which they are taking for the purpose of making them to construct? And what are the steps which they are taking for the purpose of penalizing those who do not comply with? But they have not said. Under the bylaws, it is required now. So far as the new buildings are concerned, under the bylaws, your lordships may see at the page 3, the summary of latest status reports, I have stated. Because they are rural, all the 4 reports are summed up. All the summed up, because all the reports together, because instead of individually dealing with each of the report, your lordships may see the reports of R3, I said, speaks elaborately about the statutory and regulatory provisions. In place of rainwater harvesting, it is stated that issuance of occupancy certificate is subject to the construction of rainwater harvesting reports. However, Parisal's RC report shows that only 26,000 rainwater harvesting structures have been constructed in all 141 urban local bodies in the entire state. Similarly, R1's report shows that the GHMC has constructed about But this is culled out from the reports, my lord, 215 rainwater harvesting structures in government structures. This reflects that there is very poor implementation of the mandatory provision in the building rules to construct rainwater harvesting structure, as well as section 17 of the Volta Act, 17 of the Volta Act. Last time also I brought to your lordship's notice. R3's report further states all the existing buildings in the urban body shall conduct RWHS within 6 months. This is vague, and unclear. They say it should be constructed. What is that? What are the steps which they are taking for implementation has not been spoken to. There is no mention of the whether, how, and RWHS will be implemented in old buildings, which came up prior to the insertion of the provisions of rainwater harvesting structure point in the above 4. There is no mention of what steps, if any, proposed to in respect to those buildings which were constructed contrary to the provisions. These are all information is lacking in the report, which I am pointing out with regard to each of the points. But subject to what your lordship say, but as it is not an adversarial litigation, I am trying to assist the court.
Yes.
I've given this copies. I've instructed my counsel, my colleague friend who is there, to give the copies to all the counsels appearing for the respondents 1 to 4. But let them look into and comply with
So given right across, we'll just put it to the and get back.
You come back to us within 2 weeks.
2 weeks.
Huh?
Because I've given a detailed note, what are
Yes,
the
yes.
lacking. Let
Yes.
them look into and let them answer,
Yes.
each one of them.
Mr. T. Prakash Reddy, learned senior counsel stroke.
For the writ petitioner, your lordship, it's a batch of writ petitions, your lordship. One batch had come before your lordship on 22nd September. Your lordship had directed all matters to be posted along with them, your lordship. I'll pass on the docket.
You argue, madam, this case, the batch will take care of itself.
Problem is, your lordship, matter had gone to Supreme Court, and that matter was restored, your lordship. Accordingly, interim order is in that matter, and all are tagged together, your lordship. In fact, all documents, because we are the counsel in 3-4 matters, all documents pursuant to the Supreme Court order, we have filed in that matter, not in this matter. In fact, one matter came up 2-3 months back. I gave a letter to the Registrar Judicial to club all matters. I have not filed all documents in this, your lordship. That's the main reason. And Supreme Court had granted me liberty to file all other additional pleas, your lordship.
No, madam, that liberty was granted when?
If your lordship grants a short password, I'll get that Supreme Court order, because in
No, it's pending up since 18 years, madam.
yes, your lordship, what
Not
I have,
our case. We are not going to get any increment by deciding this case. There must be interim order in your favor. That's why your client has forgotten about it. You don't want to prosecute.
individual
What is
interest.
this?
I'm
There
not,
can't be any justification in seeking adjournment in old cases like this, madam.
your lordship, I
You have to
challenged,
cooperate.
I have challenged the IT policy, your lordship. Land acquisition proceedings, I have challenged. This is not the only writ petition I have filed from.
Also, you argue your own case, no? The other will take care whatever we decide in this, supposing if this petition is allowed. they will also be allowed. We can't take contrary view in your case,
Unlike-
dismiss your case and allow other petition. It can't happen.
Unlike other final hearing writ appeals, Your
That order which we pass will bind us also. Please argue, whatever it
The
is.
problem, Your Lordship, this matter was listed last night only. Unlike other final hearing matters which have been coming up regularly, the only thing is I need to put
Regularly?
on those other documents also because Supreme Court granted me liberty, Your Lordship.
No, this has been this thing disposed of FLP.
This is not a complete set, Your Lordship.
Whatever said, you argue, madam.
How can I argue, Your Lordship, based on incomplete set when Supreme Court permitted me to file additional documents?
So additional to what? When was the order passed by Supreme Court? What you were doing? Like when the case is called, then only.
Special bench was constituted, Your Lordship. It used to hear it. Thereafter, it never heard, Your Lordship.
So it should not be heard according to you,
It
right?
should be heard, but with complete.
Heard means whose responsibility? It is not our responsibility to file pleadings. You are the litigant here, not us. Who will file the documents?
Your Lordship, if I have 5 cases, sir, in which I have challenged everything, for the convenience of the court as well as the party, I file compilation, additional evidence, additional pleadings, everything in one set. Suddenly this.
And you argue tomorrow, madam. The thing which give the number. This we can't do like this.
I pass the docket order.
List along with these writ petitions tomorrow.
Obliged.
You have to cooperate, madam. Like we need this thing. Do you call yourself officers of the court? This is the conduct, right? All the time seeking adjournment.
Genuine reason I
No genuine. You genuine. We would have understood if you said that. Please take it up tomorrow. I will argue. That would have been genuine. You are just passing on the list. As if it is our case, we will succeed in this land acquisition proceeding if petition is allowed. That is what, madam. Have some mercy on your clients. Have some mercy. All the time passing on the this thing, blame to judges, not good. Right? Everything the judge doesn't hear, they don't work. What can I do?
We never pass on such
Yes.
information to clients.
Please argue tomorrow. No adjournment tomorrow, madam. Please argue. Or don't come. If you have to seek an adjournment, please do not come. We will see the file. We will decide. See, brother. What is it? See. No, no. 46 years. No. No, all right. You see what is. Yes.
That is. The writ appeal is filed, Your Lordship, against orders in writ petition.
Huh? What is the issue must have been rendered academic. It pertains to grant of building permission. We'll see first year on.
Next. Writ appeal is filed, your lordship, against orders in WP 933 of 2008, 6, your lordship, dated 6/8/2008. Setting aside the orders of the government passed, exercising the jurisdiction, their government's jurisdiction, revisional jurisdiction under section 679 of the HMC Act, your lordship. Permission was granted, your lordship, to the in favor of the writ petitioners on 5/6/1992, when earlier the application was rejected 4 times, only on the basis that the first writ petitioner has given an undertaking that he is not going to claim compensation for the land which is coming under road extension, when that is not the criteria on which the building permission has to be granted. Earlier, the main application was submitted on 8/12/1969, your lordship, by the first writ petitioner. That was rejected on 13/5/1970. Was directed to furnish documentary evidence and no objection certificate from the district collector and the work board at that time. On 21/11/1970, he resubmitted the application without furnishing any
Sir,
other.
have you prepared some synopsis?
I have given the synopsis, your lordship.
I also submitted synopsis.
Where is it? So that at least we can refer. What is like the building permission was cancelled, right?
Not,
What is now, what survives now?
I'll sum it up if you lordships permit me in 2 sentences. A permit was granted to the writ petitioners Lord on 5/6/92.
5/6.
Challenging that a revision according to us is not maintainable before the government was filed in 2003, 1912.
Who filed the revision?
Submit, your lordship.
1 minute. We are just trying to understand, madam.
That's what I
It can't be decided without hearing you. But we
Yes.
just want to understand what is the controversy. That's why he is assisting us. So building permission was granted on 5/6/92 to the petitioners.
To the writ petitioners.
Okay.
Lord, that was challenged by a person who claims to be a title holder to the writ petitioner.
He is not a party in this petition.
In the writ petition is a party.
Who challenged by
Challenged by
Respondent. Writ appellant has challenged the building permission, your lordship. Yes.
In revision.
In the writ petition, he is
writ
responsible.
No. 1 minute, madam. Have patience. We will hear you. We are just trying to understand, right? What is the
I want
point?
to argue the matter, my lord. I only put the perspective.
Yeah, that's why.
So-
He is not arguing. We are just trying to understand what is it about.
So, my lord, R3 in the writ petition filed the revision petition before the government under 679 of the Municipal Corporation Act.
679.
Of the Municipal Corporation Act, challenging the permit of 1992 on 19/12/2003. Meanwhile, there were several suits and in which, according to us, they lost all cases. So a revision filed after about 9 years was allowed on the ground that at the time of permission, you have not produced the title deed to the corporation. So that order is set aside by the single judge.
Okay. And this is an appeal preferred by respondent number 3.
Yes. So question is the title dispute person will not files the, that's all.
Yes. Yes, madam.
My please. I'm the owner of the plot, your lordship. Having been granted, the land was granted to my father by Amire Paiga. This is a part of Bashirbagh Palace, your lordship. It is a allotted land to Amire Paiga in CS 7 of 19.
What palace? Part of what palace?
Bashirbagh Palace.
Acha. What is
It is-
Bashirbagh Palace?
It is a
Has
palace.
it any relevance to the case?
This is how he got the land, I'm just telling you.
Ah.
This is a part of CS 7 of 1954, Your Lordship. And graves of Nawab were placed in the palace. This land, graves and the land for raising a residential complex for himself was allotted to the father of the third respondent. And this writ petitioner, and as he was not well, Your Lordship, he has appointed a guard for guarding the lot and has gone for taking treatment. And this Muniruddin, who is the close relative of this guard, and he has taken cycle permission from the GHMC. And with that, he has got his name mutated.
Dispute is only with regard to this order, no building permission and order.
Yes.
Title we can't decide in a writ
That's what I'm
petition.
saying. Without permission, without submitting all the statutory documents,
Act, madam.
without submitting all the
Municipal Corporation Act.
documents as per the building bylaws, he has applied the building permission in 8/12/1969. That was rejected on 13/5/1970. And that was
Go ahead, we are hearing.
as your lordship wanted to see the statutory reference, I was just going to that. And this was rejected, your lordship, in 1970. He resubmitted it in 1970 again in November. I've given a synopsis of the dates, your lordship. And on 7, again, when that was rejected, he submitted it on 21.
He means respondent number 3.
Yes, yes.
He means respondent
Yes.
number 3.
He expired and his LRs on before, your lordship. And on 11 to 1972, 76 again, he submitted the plans and they were returned, rejected, unapproved. And he applied again on 25/1/1983. But that was also rejected, but applications again was refused on 4/6/1983 because of the change in personnel in the GHMC office. This was approved when the land was, he gave an undertaking that he is not going to claim any compensation for the land which is coming at the land road widening. That was given on 5/6/1992. The application was made in 8/12/1969. After 4 rejections, suddenly this was approved. Building permission was approved on 5/6/1992. Only taking that consideration, taking that his undertaking into consideration, claiming that he is not going to claim any compensation for the land which is coming at the road widening. And when he started raising construction, when we interfered, he filed a suit in 1994. That is a permanent injunction suit in 1994. And as we also filed a suit, your lordship, for the cancellation of this building permission. And as suit is not maintainable, this application under 679 was filed. This was taken into consideration and he has filed his counter. He has filed all the documents which he claims that he has won the suits. And all the suits has been filed by the Waqf board, and he has not filed any suit against us for declaration of title. And there's when the Waqf board lost the case, he claimed that he is the owner of the land and he started raising construction. And that too in deviation also of this permission, he raised construction, your lordship. And when we filed the application under 679 of GHMC Act, May I take your lordship to 679? Power of revision, your lordship. The government may at any time, for the purpose of satisfying itself as to the correctness, legality, propriety or regularity of any proceedings or order passed by the commissioner or any officer subordinate to him, call for and examine the record and pass such orders with reference thereof to as it thinks fit. So the application will under 679 at any time it is stated, your lordship, they have called for the records, main records and all the application forms, everything, and he submitted the judgments copies claiming that he is the owner on the basis of those judgments and has passed this order. This order, they have clearly given finding that as per 429 AA, your lordship, he has not annexed the title deeds. 429, your lordship. Chapter 12 deals with the building regulations, your lordship. From section 428, this is 429. Commissioner may require plans and other documents to be furnished at any time within 30 days after receipt of any notice under section 428. The commissioner may, by written notice, require the person who has given the notice first hereby herein before this in this section mentioned to furnish to the commissioner all or any of the following documents, namely correct plans and sections of every floor of the building intended to be erected or re-erected, which shall be drawn to a scale of not less than 1 inch, so and so. The relevant portion is, your lordship, A copy of title deed of the land duly attested by a gazetted officer of the government together with an urban land sealing clearance certificate, or as the case may be, an affidavit referred to in section 388. He has not annexed any title deeds along with the applications. And even as per the bylaws, your lordship, which I have given a copy earlier. Bylaws. Fine. In the channel. Building bylaws of 1981, your lordship.
No, must be knowing. Who appears for municipality? What happened to this final application pending for building penalization?
It has been rejected, they said, your lordship.
See, the direction is to consider for the. So you must be knowing, right, whether the building penalization scheme application was considered or not. That was the direction.
That second portion, my lord, I mean, that was not challenged by us. The other single judge.
No. This, there was a direction to consider your application.
Yes.
So the query by brother is whether it was considered pending. Not decided.
Not decided.
I am told that it is rejected already, your lordship.
Declaration, my lord, this honorable court state the regulation for permitting the corporation has issued some regulation for regularizing illegal construction. That was challenged in TIL because government corporation cannot always regularize illegal construction. That is state by its own. That's why
that
no
GO was
has taken.
That GO was set aside by this honorable court, earlier GO, and subsequently another scheme was issued. But we are not aware as to whether he has applied under the second scheme or not. But the first one, we were informed that it's already rejected. When as per the building bylaws, Your Lordship, they have to submit this title deeds, but they is not annexed. And by taking all these view into consideration and all the documents and the mail and the original application submitted by the writ petitioner, these orders were passed, Your Lordship. It's at page number 45. Relevant portion from 46 onwards, Your Lordship. Para 3. Heard both the parties and government after careful examination of the matter and the records of Municipal Corporation of Hyderabad relating to permit number 371/4 dated 5/6/1992 observed that in 1991, though the Waqf Board wrote a letter to the Commissioner Municipal Corporation of Hyderabad clearly stating that third respondent Sri Muniruddin is an encroacher and land grabber and requested the Commissioner Municipal Corporation of Hyderabad to refuse granting of permission, the plan was approved on the basis of the copies of the judgment in suit, appeal and LAP between third respondent and the district collector and the judgment filed by the third respondent on 13/9/1991. On seeing those judgments, Municipal Corporation sought for an undertaking from Muniruddin, the third respondent, to effect that the third respondent would hand over the land coming under road widening to the Municipal Corporation of Hyderabad free of cost and without claiming any compensation for the land as the condition precedent for the sanctioning of the building permission. Though no title deeds were submitted as required under 429 AA of HMC Act 1955, the Municipal Corporation Building Bylaws number 4.25 of 1981, the Municipal Corporation of Hyderabad has accorded permission when the third respondent agreed to hand over the land coming under road widening. Thus, the permission granted to the third respondent, that is Muniruddin, through the permit number 371/4 dated 5/6/92 in the file so and so by the Commissioner Municipal Corporation is contrary to the section 429 AA of HMC Act and Municipal Corporation Building Bylaws 4.25. As the permit 371/4 dated 5/6/92 issued by the Commissioner Municipal Corporation of Hyderabad is hereby cancelled. Hamiduddin and third respondent are at liberty to settle the ownership dispute in the appropriate court of law and approach the Commissioner Municipal Corporation of the Hyderabad with a valid title deed for issue of necessary building permission. The Commissioner Municipal Corporation of Hyderabad shall consider the building permission after giving due opportunity to both the parties and dispose of the same as per the law and as per prevailing rules by taking documentary proof of title, etc. into consideration. After obtaining this illegal permission, Your Lordship, without giving any notice to the Commissioner, he started construction beyond the period of 1 year. That is after lapse of the permission. And when notice was given under 452 of HMC Act, he filed suits, took injunction and raised construction. And when demolition notice was given, and that was subsequently dismissed for default, he got the injunction and the guise of injunction, he continued construction. And he got the suit dismissed. Suit was subsequently dismissed for default. Again, when another notice was given, Your Lordship, he again files a suit, obtains injunction, and continues the construction, and even that suit was dismissed. And on coming to know about filing a further suit, that is 601, we filed an implead petition. Our implead petition was dismissed. We challenged it, before this honorable court, and that was dismissed in 2003. And as suit is not maintainable for cancellation of the building permission, we were constrained to file application number 679. Now they are claiming that we have filed this application after long lapse of 1992. They are obtaining permission in 1992. Their initial application is in 69. When 4 times that was rejected, their permission was granted only on the basis of he giving an undertaking that he is not going to claim any compensation, which is not a requirement for granting of permission. When statutory requirement is not furnished by him, the title deed is not furnished, which is statutory and which is mandatory, he cannot go on raise construction and say, I am the owner, I have already raised construction. In fact, for grant of permission to a person he cannot claim any title over the property. And as per the count of the THMC lordship, it is clear that he has raised construction only under the guise of injunctions and has even deviated from that building permission also. Here the building permission was granted in 1992, but the learned single judge takes the judgment of in suit, only mere permanent injunction suit, that is filed in 1994 against me, that is the expert decree was passed ex parte. It takes that into consideration and claims that I have lost all the cases against him. No case is filed against me by him to declare his title, and his title is not declared against me, and he has filed only suits against AP Bakpur and third parties, wherein he has not impleaded me, knowing fully well that I am the one. And those judgments are not binding on me, Your Lordship, because any civil suit are binding only against the parties which were against whom the suit is filed. This is not as though, Your Lordship, when an injunction is taken, he has injuncted me from interfering with the construction. And even he has taken injunction against the statutory authorities, that is GNCC authorities, from demolishing the building, which is being illegally constructed. Like, bring Your Lordship's notice to the counter filed by the GHMC. That page 61, Your Lordship. The government also, Your Lordship. Government counter is at page 58. And this is clearly reiterated that he has not furnished the documents as prescribed under 429 AA and the building bylaws 4.52. Given a copy of bylaws. Which are these are the building bylaws of 1981, Your Lordship. As per this, Your Lordship, title deeds have to be annexed at page 542, Your Lordship. Application 541, the application for building permit is given, Your Lordship, and all the documents which are to be annexed as specified. At page 542, above 4.211, Your Lordship, 545. Ownership title, Lordship can got it. Every application for building permit shall be accompanied by the following as proof of ownership. A attested copy of original sale deed, lease deed, and attested copy of revenue survey sheet, stroke municipal survey sheet with mutation record number, affidavit or other documents acceptable to the Commissioner MCH. There is a clear finding that these documents were not annexed along with the building permit. And even the constructions, Your Lordship, are made only under the basis of the injunctions taken against the municipal authorities. Counter, Your Lordship, of the municipal corporation, page 61. Seven 63, Your Lordship, para 7 is submitted as per the building bylaws number 7.1 of 1981. The permit is valid up to 3 years from the date of receipt of the permit, subject to condition that if construction is commenced within 1 year, that is before 5/6/1993, because he got the permit on 5/6/1992. Further, as per the provision under section 440 of HMC Act, petitioners are required to give commencement notice under section 440 of HMC Act to the respondent number 2. Whereas the petitioner has not commenced the construction work within 1 year from the date of receipt of the permit. Hence, the permit dated 5/6/1992 is deemed to be lapsed. Further, the petitioner have commenced the construction work without issuing the commencement notice under section 440 of HMC Act. Therefore, the respondent 2 has issued a show cause notice under section 452 of HMC Act dated 6/6/1994. Agreed by the show cause notice, petitioner number 1 filed OS 607 for perpetual injunction and the respondent herein from interfering with the construction. The Honorable First Senior Civil Judge, City Civil Court also granted interim injunction order on 10/6/1994 in IA 686 of 1994 against respondent number 2, and ultimately suit was dismissed on 28/9/2000. After receipt of the injunction dated 10/6/1994 in IA so the petitioner number 1 proceeded with the construction work without permission and made the following deviations of sanction plan, which was lapsed. No frontage, the 12 deviations are shown, Your Lordship. Petitioner number 1.
Continue tomorrow. Further hearing. List for further hearing.
The synopsis of, I'll serve copy.
The item 47, we have given no objection certificate, a name may be deleted.
37, which
Next
case?
slide, next slide.
You are not appearing.
No.
Mr. So and so, 47. What's his name? Appeal, read petition. Mr. So and so, learned counsel submits that he has no instructions to argue the matter. The appeal is therefore dismissed for want of prosecution.